You're live.
Good morning. This is Thursday, February 9th, 2023. And we are taking up S3 in Senate Judiciary and Act relating to prohibiting paramilitary training camps in Vermont. And our first witness this morning is Chris Bradley, President of the Vermont Federation of Sportsmen's Club. But we do have a redraft of the bill that I think everybody has seen. So testimony to the redraft, which is draft 1.1, Eric.
Yes. Strike all amendment, exactly.
Senator, it says Senator Baruch moves the bill to be amended by strike off.
No, this is the original.
I have 2 copies, so maybe I have yours.
Oh, sorry.
No.
Yeah. that would be-
So we'll be working from the strike off. Do you need a copy?
Yeah.
You have some more copies?
Sure.
She'll make some.
It's on the webpage, but
Yeah.
I'll print it.
But yeah, you can print up the strike off.
Mr. Chair,
Yes,
do you think we should do a walkthrough prior to?
that's fine. Yeah, briefly. Eric, can you do that walkthrough? Or do you want to do it, Senator?
No, I think Eric.
Do you want to share your screen, Eric?
I
He said, did you get a law degree?
Thank you.
I could do
You're closer.
Would you like to share the screen? Would that be easier for everybody? I could just do that.
No, I think you make copies for those that are here and share the screen is fine. Do both, please.
Okay. Well, I don't do one at a time, so.
You don't let me see behind you.
Not at all. I trust you.
Likewise.
Actually, Eric, no.
Morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to do a walkthrough of the strike all amendment proposed by Senator Ruth to S3, the Act relating to unauthorized paramilitary training. So just a moment of background, and just to remind everybody that you heard some testimony, I think it's been a couple of weeks now, that there's a number of other states that have similar statutes to the strike all amendment that you're looking at right now. So this language is based on, in particular, the 2 statutes from Florida and Virginia. So I also looked at Minnesota, Connecticut, all very, very similar. We're not going to say verbatim, but very, very similar. The language is quite close to what you're looking at now.
So this is similar to Vermont, to Virginia,
In Florida, yeah, in particular. I mean, they're all very similar. Those are the 2 that in particular that I use as a model for the language that you're looking at here. It's not just conceptually similar, the language is in many instances quite similar as well. And it's not just those states. It looks like there's in the neighborhood of 25 states that have passed something extremely similar. So, and what that is in each of these states is a prohibition on teaching, training, demonstrating certain things, use of firearms, explosives, or incendiary devices, or techniques capable of causing injury or death, if the person teaching, training, or demonstrating them knows or reasonably should know that teaching, training, or demonstrating will be used in a civil disorder. See? So it's not just the teaching, training, or demonstrating. A person could teach, train, or demonstrate firearms, explosives, incendiary devices, etc., assuming it was otherwise legal. If that were the case, that'd be fine, as long as the person didn't know or reasonably should know
They get caught.
that it was going to be used for a civil disorder. Everybody get that? So it's a 2.
Geez. That was, did you get any on? Oh, it's a good thing it was shut. Thank you, Eric. That was a little
Sure.
Real life.
Yeah.
equipment malfunction.
Yes. So anyway, just wanted to make that clear, and you'll see that in the language. And it's not only, so it prohibits the 2 things, not just teaching, and that's subdivision 1 of page 11. Everything I just described is subdivision 1. That prohibits the teaching, training, demonstrating of firearms, explosives, incendiary devices, or techniques capable of causing injuries or death, if, and only if, the person knows or should know that teaching, training, or demonstrating will be used in a civil disorder.
Quick question for
Yes.
you. Is any of this under the domestic terrorism statute?
Thank you. No, not right now. The reason it was the domestic terrorism statute was oddly placed. And I looked at that and I was thinking that, oh, there's a domestic terrorism chapter. This would fit in nicely. But there isn't one. The domestic terrorism statute itself is just one statute that's sort of stuck oddly in another, only one section, I should say, not a chapter. So what I did was, organizationally, you'll see right now, the weapons chapter has two subchapters. One is just sort of general variety of weapons, everything with firearms, other weapons, that sort of thing. The new statutes that you pass and amendments that you make to the firearm statutes are all in this first subchapter of the weapons chapter. There's a second subchapter of the weapons chapter that has to do with the ERBOs, when you passed a few years ago, the extreme risk protections orders. So what I did was I just made a third subchapter, unauthorized military training, within that weapons chapter. Just seemed like, not that there's only one right answer, but I was, because you were right, that would have been a great fit if we could, if there was a domestic terrorism.
Make the domestic terrorism chapter.
Yeah, that could be right, that might be the best necessary. No, but long term, that might be a good move.
Yeah.
Well, I think it might be.
So anyway, that's why organization-wide it ended up proposed to be where it is. So that was the first piece, subdivision 1. That was the teaching, training, demonstrating. It also prohibits in subdivision 2 assembling with one or more persons for the same purposes that I just described. So the teaching, training, or demonstrating is prohibited in 1. In other words, you can't teach or demonstrate use of firearms, etc. But in subdivision 2, you sort of think about conceptually who's getting prohibited here. In the first subdivision rather, it's the people doing the teaching. In the second subdivision, it's the people assembling with one or more other people to receive that exact same kind of training. Whether it's the training in, firearms, incendiary devices, explosives, etc., or the training in, techniques capable of causing injury or death. Again, as long as it's connected to the fact that they know the person doing the training or receiving the training knows or should know that it's going to be used in a civil disorder.
Is the burden on the state to prove that they know or should have known?
Absolutely.
How would they prove something like that?
It's particularly what should have known, always a more difficult thing to prove. Again, you would have to have enough circumstantial evidence that you would think either a court or a jury, applying the standards of the community, would think that a reasonable person in that situation, for example, maybe there wasn't, in the syllabus, subsection 1, here's how we're going to use this in a civil disorder, but there might be, by the nature of the training, by the nature of the conversations that go on with other witnesses, by the types of weapons that are being used in the discussions that are had as to the sort of situations that it would go in. But admittedly, I think as you're kind of getting at, without that proof, you couldn't make that case. You'd have to have something. And
Many times people are embedded within these organizations who are
point,
either law enforcement or working with law enforcement.
right.
Exactly, and then the other piece, and the January 6th events and prosecutions point this up. These days, it's text. Again and again, these people believe they're using encrypted texts or text that will be impossible for law enforcement to access. And then you have a conversation laid out where they're talking about exactly what they're going to do and how they're going to do it. So that's why so many of those prosecutions at the federal level have moved so quickly, as they have text and video.
Yeah, I guess I want to make sure that we are able to proactively stop these kinds of things rather than reacting after civil disorder or disobedience happens. I think looking back, we can say, well, of course they were training to have an insurrection, because
Right.
then they tried to have an insurrection. But I really want to be thoughtful about thinking proactively and how we stop things before they happen.
And there is, at the end, this injunctive relief.
Yes, I was just gonna
Okay.
point that out, right? It still, as you point out, Senator, still has the proof issue. They're still going to need to have something, but it's a nice segue to jump right to that last section. We'll come back in a moment for any definition you want to look at, or the exceptions in particular, I think are helpful, but it is a good segue to the bottom of page 3. This is an additional concept that some other states have. It wasn't in the original bill, but it's this concept of civil enforcement by the Attorney General's office or state's attorney. So if they have probable cause And that's similar, says reason to believe, but just the idea is similar, yeah. The reason to believe that the person is violating or about to violate section 4071. So in other words, what we just went through, that's what the unlawful conduct would be. You know, training a person to use explosives or firearms in a civil disorder. They have reason to believe that that's about to happen or is happening. Then they can bring an action in superior courts to get an injunction to have the court order that be stopped before it happens, as you were saying.
Quick question, Eric, the injunctive relief, does that last 14 days or is that a TRO that only lasts 14 days?
These ones don't, there are some other statutes that have that specific time limit, but this one doesn't, I don't think there's anything in there specifically about the time. So ordinarily, if it's a temporary restraining order, then that requires that the court set a hearing for an injunction after that. So the TRO, you can do very, if something needs to be happening on an emergency basis, as I'm sure you know. I don't know if there's a 14-day limit in that or not, or if it's sort of like whenever the court can get
So
that.
the injunctive relief lasts until, how long would it ordinarily
Court can
last?
set a time.
It says temporary or permanent injunction.
Right, could be permanent. Usually that's after, like a temporary hearing is first, sometimes with a temporary hearing, a lot of times similar to what we've seen in ERPOs and RFAs, things like that. Temporary hearing can be an emergency, not, it can happen that the opposing party isn't there. You know, you can do that without the presence of the defendant, but you have to have a quick hearing afterward. That would be the injunction, so that they have the right to come and, you know, defend themselves.
And one more question. Sorry if you were about to get into this, but
No.
if an injunction is granted and the camp keeps going on with their activities, how would it be enforced?
Well, the state could come in two things. It would then be the criminal violation under the first part of the bill, but also violating the injunction itself could be another offense that the AG could bring. So, thanks.
Maybe I could read from today's Bennington Banner.
We hadn't saw that.
Did you see that?
Yeah, please read it. I haven't read the banner.
I think it was the banner.
I think I saw it there.
Maybe it was in Digger, yeah. Maybe it was.
Well, I did read the bigger one.
Anyway, the court is saying to Slate Ridge, come on, it's time to tear these buildings down, and we have to give you a reasonable time, but, you know, he's just stalling and ignoring it. I want to get the term correct.
Well, and I think it underscores the need for this sort of injunctive relief, is that, you know, this is dragged on for, you know, going on years. It's like and there should be a cleaner way for the administration to deal with it.
Can I ask a process question, just because I'm not super familiar with the system? Why would this go to Superior Court, not criminal court?
Those are, because that action to shut well, in this case, to shut a facility down, but in general, to stop conduct, whatever it may be, that's a civil action, not a criminal action. That's the reason.
The environmental judge Thomas Burton has ruled that Daniel Gagne, owner of controversial paramilitary training facility Slate Ridge, has violated court orders and will go to prison if he does not deconstruct unpermitted buildings on his property to the schedule set by the court. Gagne has demonstrated willfulness, perhaps even an enthusiasm for disregarding the town's bylaws, the court's orders, and the authority of the judiciary. Ruling marks the latest in the case, began in 2019, blah, blah, blah.
I should have said that too, Senator Hashim, in response to your question. That's another, I'm sure that's part of the foundation of that case. If the AG had gotten the injunction, which means the court had issued the order, and there's still a defiance of it, that's contempt of court. So that's another criminal offense. I think that's criminal contempt. It subjects the person to prison. So,
Yeah, I think being fined
200 a day.
He's been ordered to pay the town more than 45,000 in fines. And he's got $200 per day, which began January 14th, 2022. And that's a total of 78,000 Georgia Road. Anyway, on page 2, you have the exceptions.
Yes, that's the.
Did we skip over them or?
No, we haven't talked about it yet.
Okay, because I was reading them and I have one question.
Yes. So yes, you see, there's a number of them.
Maybe you want to go over the exceptions before I ask my question.
Either way, but happy to start in at least. So yes, you'll see there's a number of them attempting to broadly exclude the type of conduct that's not intended to be covered within the bill. So the first one is standard language you've seen in a lot of places. It's basically legitimate law enforcement. So that's in many firearm statutes and elsewhere in the law. So we want to make clear that this is not applying when you have legitimate law enforcement purposes, whether it's a state officer or a federal officer. That's what that first one excludes.
I have a question about that. Legitimate law enforcement purposes, would that be sanctioned by a department, or would that apply if law enforcement happens to be present at one of these training camps? Because some of the stuff that we've heard is that there are people who are members of law enforcement that have been involved. So would that make it okay?
That'd be illegitimate.
Correct.
Okay, that's what I just wanted to clarify that.
Unless they were embedded. You know, in that case, they were embedded intentionally to be, like as you're mentioning, Senator Sears, a person who is, say, a confidential informant who's investigating it, that might be a legitimate purpose. But
And
if
it's similar to, and correct me if I'm wrong, to the statute against firearms at schools. So one of the conversations is always, well, what if a law enforcement person is off duty and they go there? If they're off duty, then they're not carved out and they can't have their weapon.
yeah, it's a similar exception in a number of different firearm statutes, which just since obviously law enforcement carry firearms. So be clear about that. But you're right, it has to be legitimate law enforcement purpose, not if someone happens to be there.
In the number 2, you put down Norwich University, and I wonder why single that out?
I can speak to that.
Okay.
I had an
You've
email.
heard of this spot.
I had an email from the president of Norwich University, which seemed convincing to me. He was worried that somehow they would come under the statute because they're a military university that trains in some military style tactics.
Would you believe as a freshman at UVM, I had to be part of ROTC or the
I've never heard that detail of your biography.
and you know, I don't think I ever completed the course. But, there was a lot of courses I didn't complete. So we won't go into the details. But yeah, we were required at UVM. I don't know if they still do. I think they did away with all that after. I think it was 1963, so it was before.
I don't know, though. I have had at least one student who I thought was an officer in training at UVM. So maybe they still have a small program.
They may have. But anyway, I remember, you know, we had these big guns, rifles we had to carry around the plane.
Well, it's,
But they never gave us any bullets.
it does include any other educational institution.
No, but it could.
No, it does include.
Yeah, any other. So you felt, okay, it's fine if you want to name Norwich
And that,
with me. I just wondered why we were naming a university.
again, would apply to instruction at Norwich, not if a Norwich student is simply engaged in.
Right.
Okay.
Yes, exactly. Yeah. So that's the second exception. Third one has to do with sort of essentially self-defense sort of techniques. And this, I think, I took specifically out of the Florida statute. Activities undertaken without knowledge of or intent to cause or further a civil disorder. So making clear this is not any sort of teaching that's going on with that intent to cause a civil disorder piece that is essential to the crime. And line 12, that is intended to teach or practice self-defense or self-defense techniques, including karate clubs, self-defense clinics, similar lawful activities. So as we know, those sorts of clinics go on in a variety of different contexts. And the idea is to make sure that that wasn't, because you're specifically, the language, you remember in the techniques capable of causing injury or death to persons is one of the specific pieces of language in the crime. So the idea is to make sure that it doesn't prohibit self-defense instruction. Number 4, this is firearms instruction and training. This is basically what number 4 is. Any facility, program, or lawful activity related to firearms instruction and training that is intended to teach the safe handling and use of firearms. Again, safe firearms use courses. And number 5, hunting. And this is also something that's been accepted in different firearm statutes, but any lawful sports or activities related to the individual recreational use or possession of firearms, including hunting pursuant to the statutory chapter that covers hunting, target shooting, self-defense, and firearms collection. So again.
And if I could, Eric, I just wanted to point out that those carve-outs speak to, since the bill went in, I've been contacted by a number of people talking about what they perceive the potential unintended consequences involving just these sorts of lawful sports activities, et cetera. And so these are an attempt to fence all of that out. And then the bill's first sections are devoted to fencing in civil disorder that we can prove is the intent. And so my thought is that this should take care of many of the concerns that were expressed about the original version of it.
I think it's very good.
And just the last thing I'd say is that that was a nice segue into the definition of civil disorder. And also, top of page 3, important part of the act or the bill, since obviously the criminal piece is tied into the intent to cause a civil disorder. Well, what is the civil disorder? Any public disturbance involving acts of violence by an assembly of 2 or more persons. It's got to be a violent act, 2 or more people, that causes an immediate danger of it or results in damage or injury to the property or person of anybody else. So it's got to have 2 or more people assembling involving acts of violence causing injury to persons or property. Essentially.
I'm glad that we did this walkthrough, and now maybe we can go to
Yes,
Mr.
absolutely.
Bradley for.
I just have one quick question.
Sure.
In my reading of the strike all amendment here, which I think is very good, I personally, I'm just speaking on my behalf, I personally don't see anything that comes close to any form of a Second Amendment issue here. And I was just wondering, Eric, in your opinion, do you see anything that comes anywhere near a potential violation of the Second Amendment here in this lawsuit?
No, and I looked at the press of the Illinois, admittedly older case from 1886 that specifically upheld a state statute that in part prohibited private militias like this, and the court said not a Second Amendment.
1886.
Yes, okay.
George Lanello.
There we go.
That's right. Well said.
Well, thanks, and I appreciate that, because I'm sure the last thing this committee wants to do is to even come close to any violations of the Second Amendment right, and I think this is a good walkthrough.
Right. Thank you.
Can I just, so just again, because I don't know the criminal codes, would this be a felony or a misdemeanor?
Felony, it's a 5-year felony.
Okay.
Just for, and it's just it's a good point. I should have mentioned this at some point earlier on in my in this testimony, just to remind everybody, 2 years is the threshold between felony and misdemeanor. So if it's 2 years or more potential imprisonment felony, less than 2 years.
Right. $5,000.
I think that's right. Double check that.
Yeah, it says 5 years and fine not more than 5,000.
And would this be considered a violent crime?
That, there's nothing specific said about it. So it's going to be a matter of interpretation for the courts, but it's hard to, since the if I remember correct, yes, the civil disorder violence is an element of it. It's hard to imagine it not being found in crime of violence.
Okay, thank you.
Yeah.
Okay, Chris Bradley.
No, sorry.
Full red light.
Thank you for both you and James for willingness to delay a little bit to go to Eric.
Good.
Feel free. Good morning, Chris Bradley from our Federation of Sportsmen's Clubs, an organization that's existed since 1875. In approaching S3, this is a complete rewrite. And I approached this bill first and foremost in considering the member clubs that the Federation represents, legitimate ranges that they have and the activities that are there. So the first lens I look at this is, does this affect my clubs and the activities on their ranges? And from what I see on page 2, specifically sections 3, 4, and 5, all of the activities that would be taking place at the clubs that I represent are amply covered by these 3 exemptions, if you will. Have to say I agree with Senator Norris. To argue it's difficult to see any Second Amendment issue here, especially any issue here. So I'm going to be quite short and sweet here. The only issue we see here is what you brought up, which Eric addressed, and that is, how do you prove what's in somebody's mind? And thinking about something versus the act. And that's a difficult, I read this and how would we have done this with the situation that we're looking to address? Could we have proved this? That's my only concern here. So I appreciate the thought that greatly that has been put into protecting ranges and the lawful activity that happens there. There is all sorts of training and competitions, IPSC, IDPA, that involve not just standing and engaging with target. So I'm pleased to see that that's covered. Other than that, that's my only concern, and that would be that this may be very difficult to prove. But we certainly understand the intent of this bill and what it was looking to drive at. Any questions for me? It's very rare that I don't have a scripted testimony that I read from, but this was.
Well, just one thing.
Yes, sir.
Any of your concerns for the proof of any violations right here? I think you're fully aware that the state always has to get beyond a reasonable doubt, and they also have the burden of showing or proving intent in any particular criminal case that they come. So this is no different than any other case that they may want.
I understand the intent,
yeah.
And other than that obstacle or concern, no objection. Any questions for me on this? Thank you very much.
James Block.
Hi, good morning. I'm James Lawton. I'm the state rep from Burlington.
You know everybody here.
I don't know this gentleman. I do know everybody else.
Well, let me start then. Bob Norris, Franklin County Senator.
I know Phil, they probably know me, but yeah, sure. Being around and David and my own senator. I appreciate what you have to say.
Thank you, sir.
And I think the whole thing with intent, I think there's a big difference in what's going on that they're trying to address versus the normal, shooting range, things like that. So I think one of the things that I wanted to share, because a lot of this is talk and Phil around State Ridge and stuff like that. And I'm not sure that I want to make sure that everybody is aware that there's a much bigger picture and much more of this happening in Vermont than just Lake Ridge.
Maybe if you just start with a little bit of your background, on why you were even interested in this subject. It might be helpful to the committee.
Main reason is the safety of my family. And so I always have to be extremely careful about what I say in testimony, because things I say in testimony could bring back the harassment and threats to my family. So I had to follow these organizations and these groups because they were a big part of the people who came after my wife and harassed her and threatened her. So everything I've ever done following white supremacist groups and these militia groups has always been for the knowledge and protection of my family. I hope that makes sense.
No, I just think it's a.
Yeah, okay, I appreciate that. There are other reasons why I'm involved in it too, but I can't actually talk about that. So this is one of the things, I just want to address the fact that number one, I was excited when I saw that Phil proposed this, the minute I saw it come out in the news. And I felt like at the beginning, maybe last year, people were kind of dismissing it as a one-off thing with Slate Ridge. But right now, there's a functioning group in White River Junction that has a training center too. They have a clubhouse, the whole 9 yards. Most of them are 3%ers. They have a piece of land that they do. We keep talking about civil disorder, but these people always claim to be, they're practicing for urban warfare. And I don't know if that needs to be, a wording that's civil disorder or urban warfare, because they're training for urban warfare, which means they're not training to go overseas and go fight they're training to fight here in the cities. And they believe that they have the right to protect property in cities and stuff like that. So it's urban warfare, and that is everything that Slate Ridge was teaching is urban warfare. But so did the group, which is a Vermont state militia, that they were doing the same thing in White River. There's also one in called Risky Ranch, and they're in Stanford, Vermont. And
What was the name of Stanford?
Risky Ranch militia. Yeah, some of these things nobody's ever heard of. They're a huge group. They're an extremely large group. And they are a dangerous group. They make threats that they follow through on.
When you say extremely large, how many?
They've got hundreds. Yeah, I have pictures of their meetings. And it's unbelievable how many they have involved.
Given Stanford's location right on the border, the numbers from Massachusetts.
North Adams, yeah,
Like that.
yeah, they have a code group, I guess, I don't know if that's the proper wording, but that's also a motorcycle gang, which is based in North Adams. And there's I got Risky Ranch, Slate Ridge, just making sure I cover the ones out. There's also a prepper organization in Newport, Vermont, Newport Preppers, that have been said to be building underground bunkers, getting prepared for whatever preppers get prepared for. I went to they have a website, I went to it. I wasn't going into it because they have it locked down with, they're gonna follow every IP address, that comes in. So they're gonna track you down if you go in and you ask, a series of questions that you have to ask that are very detailed information, and that's not a step that I was willing to take to go in and find out what they're doing. So we have several, as far as militias go, we have Vermont State Militia, which is very active. We have Risky Ranch Militia. We have Green Mountain Militia, and we have the Liberty Regiment, which is James Nagel, which I'm sure you're familiar with. He has a lot of good things to say about you, I'm sure. I thought he was running
Sorry,
against
just the name.
James Nagel. Yeah, wasn't he running against you, or he was saying he was gonna run against you?
I don't think
He never did it?
he ever ran.
Okay, well, he had plans on that, because I just figured I'd share that one with you. So he was heavily involved. What happened was, when Slate Ridge opened up, he had a very different setup there, and it was all about teaching urban warfare. They had, I don't know if you saw all the videos and stuff, but he had teaching you how to shoot out of the car at a target, what the windshield might how it might change the trajectory of the bullet, shooting into the car. How do you shoot into the car to kill somebody in the back when you don't want to kill the other person in the back? And it's just all about having, and we say insurrection, but it's all about having this, maybe building up for the Civil War or some type of action that, will come down the road. But, so we already have some, and we have a line, and I have people that help me do this. When I say we, I'm talking about people that help me look into this. Outside of Pomfret, Vermont, one of the things that I want to talk to you about is, like the $5,000 and stuff like that. Slate Ridge said in papers that he had invested $1.6 million in his property. I can tell you that he had a money backer, but he also has a collection of guns, more than guns, probably $750,000 worth of collection of tank busters, rocket launchers, grenades, explosives, Gatling guns, miniguns. I mean, he has a Gatling gun that could take down one of the posts out here, in a short order on the front of the building. And it was verified by the New York Times article. We had a picture of that with a ammo box that's half the size of this tape right here. So you could feed thousands of rounds in one sitting, and he also has a trailer that he attaches it to so he can take it anywhere he wants to go, anywhere. So I looked at the money backer that he had deep pockets. So what we look for when we see things like this cropping up is somebody coming in from out of state, buying large tracts of land. Okay, so there is a gentleman who's just come out here to Vermont from Texas, which kind of makes you believe they from start. Out in Pomfret, he's purchased 175 acre piece of property, and he's adding more to that. He has 2 sides of the mountain, and he's already built a road to connect the 2 sides of the mountain. We don't know for sure if he got any kind of Act 250 information on it or not, but he's already spent millions, and he has millions more to spend. So when I look at, I mean, this could potentially be a compound that would dwarf. They're on a 32 acre piece of land, which is like a postage stamp compared to this. This gentleman builds weapons for our government, and he has a I can't remember the name of the weapon now, but it is actually Wi-Fi connectable. It blows me away. But it is a rifle that even the most inexperienced person could hit a target a half a mile away, the way that it's set up. It's hard to go into the explanation of it right now, but I watched the videos on it, and it's interesting. So he's a government contractor, and he also teaches military training. So he's got all the check boxes of looking at doing something here. He's got blogs where he talked about bringing up his sons under like basically military training to make them good men when they grew up. So he's that mindset. He's that mindset of thinking. So when I look at the penalties, I think it's very easy to distinguish between like Newport or Norwich and what they're doing and what these people are. It's very obviously a different kind of training. But what Slate Ridge and this gentleman has is deep pockets, big money. And I know that Slate Ridge lost their, I think they lost their money. That's why they struggled a little bit more financially. But this other guy is a millionaire, and they're going to have access to lawyers that could crush anything that comes their way.
Let me understand this. The person from Palmford has a contract with the United States government.
Yes. For he,
I would have thought that the United States government would have checked out the people they're contracting with.
well, I don't know if that's why he's moved from Texas to Vermont.
Yeah, I
Just let
I
me know.
just, I don't, I appreciate the heads up. I just wonder if somebody who has I would hope that the United States government checks out anybody that they have a contract with,
Mhm.
particularly to produce arms.
Oh, yeah, that's what it's called. It's a smart gun. And you can buy one if you want for 28,000.
Smart gun.
Yeah, $28,500.
Never had trouble with a smart TV. Thank you very much.
So I'm not sitting here saying that that's 100% what his
Yeah,
plans
no,
are.
I understand. I
Yeah.
just kind of being a little
Yeah.
bit, you would think that we would not, we as the,
But and my point about connecting with State Ridge is, with that type of money, these aren't just the next door neighbor doing this stuff. You know what I mean? With this kind of money, that actually, the gentleman who's the money backer for Slate Ridge is also, he's a government contractor. So I don't find that a stretch with this new guy.
no, I understood.
From everything that my crew and I have learned and through our experiences in following up on this, I've had a lot of conversations with a person from Vice News who follows these groups and figures out what they do. Usually when you see somebody come in from out of state and they start buying big tracts of land and they start trying to buy the houses or land beside it, that's typically the way it gets started. And, much like Slate Ridge, he didn't care if he got permits or not. He just was going to do whatever he wanted to. And I'm still trying to find out if this person got, an Act 250 to put a road over the top of a mountain. Whether it's his property or not, I'm sure he would have to. But it's something that just came up on our radar, so we're still doing some deep digging on that. So I'm looking at this as being even more important than when you started thinking about this process, because I know for sure that the one in Stanford has followed through on some threats they made for the Black Lives Matter guy in North Adams, the one that runs Black Lives Matter. But
Wasn't somebody from Stanford involved when there was painting in the Bennington?
well, Kevin White's involved with that group over there.
He's disappeared.
Yeah, he's still gone. They still haven't found him.
We haven't heard from that.
Yeah, he's a fugitive now. That's interesting. But they had, well, first of all, the guy who started Risky Ranch is the co-chair of the select.
Kevin was involved with the Stanford group.
Yeah, because I don't know if you remember when he was doing all the,
Lawyer.
yeah, when he was doing all that stuff with Stanford.
Yeah.
Well, the chair of the select board is the person who owns the property and who started Risky Ranch. So who's going to do anything about it? The neighbors are having some of the same issues with them as the neighbors in Paulette. But you go into the select board and they're the ones doing it, but so.
I've heard from some people over there, but I didn't realize Kevin was involved with Whiskey Ridge.
Yeah, well,
Whiskey Ridge or Whiskey?
risky ranch,
Risky.
yeah. Like risky endeavors.
Okay.
Yeah. VT Digger was supposed to do an article on him shortly after they did the one on Slate Ridge, but they were concerned for the person's safety after everything that happened with Slate Ridge, and they're like, we just don't want.
The the journal reporter was threatened. So
Oh, yeah, big time. So I just wanted to, just kind of bring that. I had more details that
I'm sorry, that's the Manchester Journal, it's a weekly paper.
Yeah, but they're still tied into the bank too, right?
Yes.
Yeah, right. Yes, he went through a lot. I was.
So the reporter for the Manchester Journal.
Yeah.
Was the one who was threatened.
Yeah.
The people of Slate Ridge.
Yes, they put them up as targets.
Yeah.
they make sure that they put a target on those people's backs. That's typically how they function. So I want to make sure you guys are aware of the fact this is bigger picture. It's been going on for a lot longer. I remember and this is what I'd like to find out for sure, because I think it could be part of this, is TJ Donovan talking about the fact that it's actually illegal in Vermont to have militias, but nobody's ever acted on it. And they've done things that completely are against whatever law he was talking about. And they did a security detail in Rutland for a Black Lives Matter march down there, which Tabitha Moore was the speaker at. And they were there with their weapons, acting like they were the police to make sure those Black Lives Matter people didn't, get out of hand. So they're doing activities like that. Slate Ridge did as well. I've got videos of him being there.
James, I think I took you off your train of thought.
Probably.
You were talking about the penalties.
Yeah, well, I don't know how, I feel like some part of that, either financially, I mean, 5 years is definitely something that send people off, but the financial part,
You think the 5,000 should be higher?
yeah. I don't think you can, $5,000 people who are millionaires, somebody came up with the money to pay Daniel Bonet's first batch of him $48,000. Somebody gave him money to pay for that. They have access to the level of money that a financial thing is, it's like the nickel to some of these people. So that's a thought.
Close to 100,000, by the way. Done it in other bills.
Yeah, it's up to, so judicial discretion.
Yeah,
But I take the point because these days, if you're working in a hot button political area, regardless of which side you go to, there are a certain number of people nationwide who will send you a small donation and you've got, $500,000 or $1 million.
Yeah.
So I've been, looking at the fines that have been assessed on the January 6 people.
Yeah.
And some of those are being paid that way.
Yeah.
As well as other similar things. So I think you're right, 5,000 is, looks pretty small when you think about that.
right, and these guys are, a lot of the people are getting, with January 6th are getting individual, as individuals are getting tagged.
Right.
Right. But what you're talking about with this bill is people who are actually running these things, which financially, in at least both cases, the money's huge. So that was a thought that I had that I wanted to at least have you guys think about, was the financial aspect of it, but also in improving it. Tanya, mentioned about how do we prove it, stuff like that. With people who have that type of money, I mean, they're going to they're going to have the best lawyers they can have, and they're going to throw everything at the defense. So that's just a side note as far as making here.
We got pretty good lawyers too. We got pretty good lawyers.
So that's it. I just want to make you aware of the bigger picture. I think that
I appreciate the bigger picture because I don't think, you're somebody who's been following, I guess.
for years.
How long has it been? 5, 6 years?
It's since
Is it
2016.
longer?
Since 2016.
2016, you've been following this.
Yeah, because honestly, I had to start out following white supremacist groups because that's who was initially coming after Kaya, but they really do cross over. The people who are involved in militias and white supremacist groups cross over. I mean, the fact that Max Mish is best friends with Kevin Hoyt, and he's friends with people who are that go to Slate Ridge, and they all are super happy with him, so they do cross over. So what led me from the white supremacist groups was the attacks that started coming from us from people who were gun people involved in militias. And so then I had to start redirecting and looking at militias to know where the threats were coming from and to be aware. So yeah, that's since 2016.
Well, thank you for reaching out to the committee and coming today.
And if you have not seen the documentary that we aired Tuesday night here, very powerful. I suggest that you all get a chance to watch it. I think you're gonna get some ideas of maybe some laws that you can look at to start, helping with this kind of stuff. It's very powerful. Our story is in it very prominently. And I don't think there was a dry eye in the house Tuesday night out of 200 some people that came to watch it. So it's called Backlash, Misogyny in the Digital Age. So when you guys do it, it's worth finding where it's gonna be shown and have a look.
Are there any other questions for James?
We really appreciated being able to do it here on the House floor. It was very powerful for Kaya and I. To have so many people that we know finally get to see it. I mean, we saw the premiere in Montreal, but the whole thing was mostly in French and we didn't know anybody there, so it wasn't quite the same, but having it here, being able to have it on the House floor was just amazing. So we're thankful for the State House and the Capitol Police, for being there to protect everybody and watch over them. So
Thank you for being here and our best to the family.
Yeah.
We have one more witness who wanted to testify on this. Bill Moore, we'll schedule him for next week. But is there any comments for Eric before we take a break?
I mean, I agree that one of the things I flagged was that $5,000 fine, I think is too low. And I think I do still have a little bit of a concern that the burden of proof to prove intent of civil disorder or disobedience may be too high to proactively shut some of this down. And I don't know what is better language, because I certainly don't want to cross into shutting down anything that is lawful activity, but I just worry about that sort of note that knows or reasonably should have known that the intent was to do to create civil disorder. And yeah.
Just to respond to this, so as Senator Norris said earlier, it's the same standard of proof to prove any crime. It's intent to commit any crime. And I think when we're talking about the shutting down aspect of it, civil enforcement, maybe Eric could share more about what the standard proof is for issuing an injunctive relief. But yeah, it's, as was mentioned earlier, it's the same standard for any crime, and it really just requires a thorough police investigation and gathering of facts and circumstances and evidence.
Eric, any thoughts? I think Senator Sheen makes a good point that in the civil as opposed to the criminal proceeding, the burden of proof is more likely than not, as opposed to beyond reasonable doubt.
So it's easier.
Easier. So to get the injunction, the AG would have a lower threshold of what they had to establish. Now, they still would have to establish, it's more likely than not that the underlying crime is being committed. So, more likely than not that people are gathering because they're teaching violent techniques to promote a civil disorder, but more likely than not is a much easier, actually, proof threshold to meet than beyond a reasonable doubt. So,
So are they using, in the civil court, are they using preponderance of evidence or still beyond a reasonable doubt?
Well, it's in this particular case, because the answer probably is some of both, because they have to have a preponderance. They have to be more likely than not that the crime is being committed. Now, the crime itself is beyond reasonable doubt. So, but that doesn't. So if you think of it, that in the sort of two-step analysis there, it's still, they don't have to show beyond a reasonable doubt in the first instance. It's just more likely than not that they would be able to show beyond a reasonable doubt. See what I mean? So it's easier than having than the criminal proceeding, which would require full beyond a reasonable doubt proof.
And that would just be for the injunction.
Correct.
Yeah.
So I guess where I view it as a little bit different than, say, I'm being charged with murder, and they have to prove that that was my intent to commit that murder. But here we're saying that we have to prove that the intent is that they might use this to cause civil disobedience before that's even happened. Because, and this is kind of what I'm getting at in terms of wanting to proactively act as opposed to waiting until the civil disobedience happens and then going back and saying, okay, well, look, that happened, so we can prove now that that was the intent. And that's how I see it as slightly different than some other crimes where the violence has happened. And I don't know if I'm making sense as to how I see it a little bit different. Like, we have to get in someone's head and say, are you planning to use this for violence in the future?
Well, I think it needs the facts somewhere. Either the embedded person or somebody like James who has seen texts or Facebook posts. Social media seems to be a great way to find out things about some of these folks.
Well, that changed a little bit after January 6th, because they were out in the open and just, they didn't care. They were flagrantly throwing stuff out there, but even Slate Ridge started dumbing down their posts after that.
There may be somebody embedded.
Yeah.
Who knows? So I think it would be dangerous personally to go down that road without providing the knowing or should have known language.
And I was thinking of the hate crime statute.
Yeah.
So we passed a hate crime statute that said someone's intent had to be wholly motivated by hate or bias, and that proved ineffective. And so we ultimately, after a couple of years, we changed it to whole or in part, in an attempt to make it more usable for prosecutors. So it may be down the road that we realize this is too restrictive, but I take Senator Norris's point. I think it's limiting it. Yes, it's limiting the state's power, but it's also giving the state power to do something it can't do now. So it's a balance in how we're approaching it. I think it's a cautious balance. That's why 25 states have adopted, including red states, is that it's not easily abused, this piece of
I think one of the frustrations that I heard loud and clear from people in the Meadowy Valley, and I represent Rupert, was the inability of the state to do anything.
Mhm.
And it wasn't until the environmental court got involved,
Yeah.
which was, not the expected route to get the state to do anything. And so I do think that this law at least would allow the state to do something. And I know there was a lot of frustration when they heard from all various state officials. There was nothing they could do.
Because there was many clear threats made to the neighbors of Slate Ridge.
Pardon me?
There was many clear threats made to
Oh, yeah.
Slate Ridge.
The constant refrain
Yeah.
from the Attorney General at the time, as well as Vermont State Police, was there's nothing we can do.
Yeah.
And that was the frustration that I heard, at least constituents up there.
Mhm.
Well, and that was my next question, and I think it might be a question for Eric, but if I have 4 neighbors that have now reported multiple threats from an organization like this, is that enough to reasonably prove that the intent of the training is to create
Was it enough
civil
to at least
disorder?
do something?
for the injunction.
Yeah, each case turns on its own particulars, but yeah, possibly. I think, the Attorney General, if you're just talking about the injunction piece to shut them down, that's the first thing that the Attorney General or the local state's attorney would have to evaluate those 4 neighbors. How credible are they? Do they have some, because sometimes when threats happen, people don't want to testify. But are they willing to testify that this happened? Are they willing to sign an affidavit? So if they could accumulate enough from those 4 neighbors, then it could be, sort of, I think, sorry to be wishy-washy in the answer. A lot of times it does depend on how firm is the proof that they're accumulating. Could be pretty good, could well be good enough. Might it be a situation where it's hard to stay without running? But to answer your question, yes, it could be.
The 100,000 for the fine.
Works for me.
To Senator Hashim's point, I wonder if we do need to create a domestic terrorism chapter that this goes under. I don't imagine this is gonna be the only time we're dealing with, just given the space we're in, things that rise to the
We did
level.
a couple of things a few years back, created that domestic terrorism, right?
Well, I
It
mean,
was like the first bill we passed in 20,
and I'm thinking of
I can't think
yesterday,
of the year, yeah.
so the governor had a press conference that I was at where he
And I
declared,
saw you there.
yeah,
Yeah, you were
where I, you know,
standing right behind the governor.
and he was calling that an act of domestic terrorism. And that involved 22 calls to swatting calls to school districts, obviously done to create disorder and chaos. And so, you know, I think we're in that space. I wouldn't want to burden this bill with trying to create a domestic terrorism chapter, but I think it is something for us to be actively looking at in this committee.
Yeah, and I think, maybe it's something we could put into the miscellaneous bill, but, I mean, this, as it is, I think is great, I just wish there was a domestic terrorism chapter that we could put it in, but, I understand logistically that's, not, we don't have that chapter right now, but I think it's a good bill. My initial concerns, had to do with, just the folks who were, target shooting in their backyard or, practicing self-defense. But, this seems very narrowly focused on people who are trying to create an insurrection or further civil disorder using violence. And, yeah, so I'm glad we have a consensus on that.
Yeah, I have no problem. And maybe if you could work with Eric, we'll work with Eric on what amendment you would like in the miscellaneous bill to have the legislative council look at creating a domestic terrorism chapter or something like that.
You mean Senator Hushain?
Yeah.
Yeah,
Sure. Yeah, sure.
I almost threw it by
I just started, Jeff, go ahead.
Oh, no, go ahead.
Well, I was just gonna say, because I was trying to remember, Jeff, refresh my own recollection. The current domestic terrorism statute is in the extortion chapter, extortion and threats. So I'm not sure how it ended up there, but.
We were in a
So-
rush.
Must be-
And what I worry about as we're talking about more and more of these things that are domestic terrorism is that they're gonna be scattered throughout like that. Like, where is this
Right.
one? Oh, it's in the
Right.
extortion, like that just, that's why I feel like having that chapter would be good. And my question though is now a process
Well, you can
question.
work with Senator.
I'm happy to do that. But from a process standpoint, if that chapter is created after this gets put into the weapons section, how does this move?
Well, they just moved. I
We're
think you just
moving
moved
them
on.
all in the same piece.
Okay, I just,
We did
I just don't
that
know.
the other day on something. I can't remember what it was.
okay,
So I think we're pretty well. When we first started talking about this, I didn't think it was going well. Thank you.
I've been surprised too, especially the constitutional firmness of it, given where the ground under all the other firearms bills got shaky. This one seems to have almost footing, weirdly enough. So
Well, I think we'll take a break till 10:20 and come back to HS 36, the